An important message before we begin. This AI-generated video podcast is intended solely for general learning and educational purposes. While we strive for accuracy, the AI may occasionally produce errors or incomplete information. Please consult qualified professionals and conduct your own research before making any legal, financial, or business decisions based on this content.
Okay, picture this. You walk up to a sleek beverage dispenser, maybe one with a touch screen, offering seemingly endless flavor combinations. Or perhaps it even recognizes your preferences. It feels futuristic, right?
Yeah, definitely.
But what if the technology enabling that experience, the smarts inside the machine, hit a snag at the patent office? What if even a company as familiar as Coca-Cola faced challenges protecting their invention?
Right. That scenario highlights how the innovation we interact with every day is built on layers of complex legal battles, often involving intellectual property.
Exactly. And that's precisely the world we're diving into today. We've been looking at a stack of sources, legal documents, court notes, detailing a specific case that landed before the High Court of Delhi. It's a case brought by the Coca-Cola Company against the Controller of Patents, stemming from a refusal to grant a patent for, well, you guessed it, a beverage dispenser.
And our deep dive isn't about judging the invention itself or, whether it ultimately deserves a patent. The real mission here, based on the sources we have, is to understand the process.
Right.
We're unpacking why the High Court stepped in, why they set aside the Patent Office's decision, and what this judgment means for the standards administrative bodies, particularly the Controller of Patents, must meet when evaluating applications and, crucially, communicating their refusals.
Okay, let's unpack this. Let's start with the core details from the sources. Who are the parties involved, and what are the essential facts here?
Sure. So on one side, you have the appellant. That's the company bringing the appeal, which is the Coca-Cola Company.
Okay.
On the other side are the respondents, the Controller of Patents, and another party basically representing the Patent Office.
Got it. And the court.
This particular case was heard in the High Court of Delhi in New Delhi, and the decision we're analyzing is dated April 17th, 2025.
April 2025.
Yeah.
And is there a case number for listeners who want to look it up?
Yeah, the case number is CA-COMM.IPD-PP 3422022.
Okay, 342-022. So what was the specific decision being challenged in this appeal? What were they fighting against?
Coca-Cola was appealing an order that was issued by the Controller of Patents way back on January 29th, 2020.
2020, okay.
And that order had refused their Indian patent application, which was number 1771 DLNP 2010.
Got it. So the Patent Office said no back in 2020, and Coca-Cola took that no to the High Court, leading to this 2025 judgment we're discussing.
Precisely.
And the invention itself, you said a beverage dispenser, but was there more to it?
Well, the application described it as a beverage dispenser designed to be an improvement over older sort of conventional machines.
Right.
The aim was to move beyond limitations like, restricted capacity and selection. It was about offering greater beverage variety and allowing for more customization by the consumer. Think about those modern machines, the ones that let you tailor your drink in dozens of ways.
Yeah, the interactive ones. Okay. So let's walk through the journey of this application. How did it get from being filed to ending up before the High Court? What's the timeline look like?
The timeline provided in the sources shows, well, a fairly standard patent examination process, but with some key points. The patent application, that 1771 DLNP 2010, was filed. Subsequently, on August 7th, 2017, the Patent Office issued the first examination report, the FER. This initial report raised several objections.
Okay. What sort of issues were highlighted in that first report? What were the initial hurdles?
The objections included concerns about lack of novelty and inventive step under Section 2.1 of the Patents Act. That's pretty standard.
Yeah.
There were also questions about non-patentability under Section 3K, which often relates to subject matter exclusions like algorithms or business methods, though the specifics aren't detailed here.
Right.
And further issues were raised regarding insufficient disclosure, lack of clarity in the claims, and unity of invention.
So quite a list of challenges right out of the gate.
Yeah.
How did Coca-Cola respond to that FER?
They filed a detailed response on March 5th, 2018. The goal was obviously to address all those points raised and convince the controller that the application did meet the requirements.
Okay, so they provided their counterarguments, clarifications. What happened after they submitted that response? Did that resolve the issues?
Apparently not entirely. Following that, the Patent Office issued a hearing notice on September 24th, 2019.
Ah, a hearing notice.
Yeah, and importantly, This notice indicated that objections still remained. Specifically, it cited the lack of novelty and inventive step again, Section 2.1, and also that issue of non-invention under Section 3K.
So even after their detailed written response, some fundamental objections were still on the table, leading to the need for an actual hearing.
Correct. A hearing was conducted on October 10th, 2019. This is where the applicant could, orally present their case and address the examiner's remaining concerns directly.
Makes sense.
But what's highlighted as critical in the sources is what happened after this hearing. Coca-Cola filed post-hearing written submissions on October 25th, 2019.
Post-hearing submissions, that sounds like their chance to really consolidate their arguments after the back and forth, maybe add final points.
Exactly. It's a standard part of the process where you solidify your position following the discussion. And it was after receiving these submissions that the controller issued the final decision, the one being appealed, the impugned order, which refused the patent grant on January 29th, 2020.
And we know the primary reason given for that refusal was lacking an inventive step under Section 2.1.
That's right. Section 2.1 defines inventive step. Basically, it means the invention has a technical advance that makes it not obvious to someone skilled in that particular field.
Okay.
The controller's position, as stated in the refusal order, was that this claimed invention lacked that inventive step when you looked at it against certain prior art documents. They'd identified specifically documents D1, D3, D4, and D5.
Can you give us some examples from the source material of how the controller actually reasoned this out? How did they connect specific features of Coca-Cola's dispenser to this prior art?
Certainly. The sources indicate the controller looked at elements in the claims and compared them to what was already known. For instance, regarding a claim that involved a consumer preference that tailors display in the user interface, the controller reasoned this was obvious in light of D1.
D1. What was D1?
D1 apparently disclosed a system of graphic display. So the argument was, well, tailoring choices within a graphical user interface is just a known application of display technology. Nothing inventive there.
So the concept of a tailored display wasn't seen as a significant leap. What about other aspects of the invention?
They also focused on claims related to getting consumer information. They cited D3.
Okay, D3.
D3 described point-of-sale terminals that had various readers, card readers, magnetic strips, other mechanisms, and it mentioned using consumer information and preferences.
Right, like loyalty cards or saved preferences, maybe.
Exactly. So the controller used this to argue that a claim about a reader configured to obtain identification information via a wireless communication was either already disclosed or made obvious by the tech in D3. Even if the communication method was wireless, the idea of reading consumer info at the point of sale was known.
So the presence of readers for consumer info and point-of-sale systems made that aspect seem, well, uninventive to the controller.
Yes. And the analysis also drew upon D4, which was cited for disclosing a controller to dispense the beverage, and D5, related to a royalty reward points program.
Okay.
By sort of combining elements taught by these different prior arts, the controller reached the conclusion that the overall steps claimed in Coca-Cola's application were obvious and not inventive. The refusal order explicitly stated that the controller had carefully considered the oral arguments and written submissions, but still found the substantive requirements, particularly inventive step, weren't met.
So the Patent Office's stance was clear. Reviewed everything, compared to prior art, considered arguments, conclusion. Obvious. But Coca-Cola clearly disagreed strongly enough to appeal. What were their main points before the High Court?
Well, Coca-Cola's primary contention, their core argument in the appeal, wasn't just that the controller got the inventiveness assessment wrong on a technical level. It was more fundamental.
How so?
They argued that the refusal order itself was flawed. They used terms like cryptic, said it lacked proper analysis, and crucially, didn't show that the controller had actually applied their mind to the detailed arguments Coca-Cola had presented. They felt the reasoning given was just insufficient to withstand judicial scrutiny.
Cryptic and lacking analysis.
Yeah.
That sounds like a direct challenge to the quality and thoroughness of the decision-making process itself.
Absolutely. And a key piece of their argument, which the sources really emphasize, revolved around those post-hearing written submissions we mentioned earlier.
Right, the ones filed after the hearing.
Exactly. They had apparently filed very detailed arguments then, specifically addressing each of the prior arts. The controller cited D1, D3, D4, D5, explaining point by point why their invention was different and why it was inventive compared to those documents. Their central claim before the High Court was that these detailed critical submissions were simply not considered or addressed in the final refusal order, just ignored.
So they felt their best explanation for why the invention wasn't obvious, submitted right at the end of the process, was just completely overlooked in the final decision.
That was the absolute heart of their complaint. Now, the sources don't dig into their specific technical counterarguments against D1 or D3 in massive detail, but the thrust of their legal challenge was procedural and analytical. They argued the controller's finding of obviousness was what they called a bare conclusion,
A bare conclusion.
meaning a statement of the result without the required step-by-step analysis showing how that result was reached, which the law demands. This is where that procedural requirement for a properly reasoned decision really comes into play.
That sets up the core legal questions for the High Court then. It wasn't just about the High Court redeciding inventiveness from scratch, but more about the legal validity of the controller's original decision. What issues did the court actually need to resolve?
Well, the central legal issue was pretty straightforward.
Mm-hmm.
Was the controller's refusal order legally sound? Specifically, was the reasoning provided for the lack of inventive steps sufficient and comprehensive, particularly in how it analyzed the cited prior art in relation to the claimed invention, and how it assessed obviousness from the perspective of a skilled person in the field.
And directly tied into that analysis
Yeah.
was the question of the submissions.
Yes, exactly. A critical point was whether the controller had adequately considered and, importantly, addressed the detailed submissions made by Coca-Cola. This question goes right to fundamental principles of procedural fairness and the legal requirement for what's often termed a speaking order.
A speeding order. Can you explain that term for us? What does that mean in this context?
Sure, in legal terms, a speaking order is more than just stating a conclusion, like refused. It's a decision that actually speaks to the parties involved. It has to provide clear reasons for the outcome.
Right.
It must show that the decision maker, in this case, the controller, has actually applied their mind to the facts and the arguments presented. And crucially, it has to address the relevant points raised by the parties. Failing to issue a speaking order can actually invalidate a decision, especially when someone's rights are being affected, like the right to potentially get a patent granted.
That makes complete sense. You really need to explain your reasoning, especially when you're rejecting an application after the applicant has provided specific counterarguments. So, bearing that in mind, what was the High Court's ultimate decision in this case?
The High Court's ruling was unambiguous. They set aside the controller's order dated January 29, 2020.
Wow, they overturned the refusal. That's a significant outcome for Coca-Cola, at least in terms of getting their application properly reevaluated. What was the court's reasoning for setting it aside? Why did they agree with Coca-Cola?
The court's primary reason, and this is really the crux of the judgment based on our sources, was that the controller's order simply fell short of the required legal standards for a reasoned decision.
Okay.
The court essentially agreed with Coca-Cola's assessment. They found the order was cryptic, that it failed because it didn't analyze the submissions made by the applicant, and consequently it lacked reasoning capable of withstanding judicial scrutiny. The court specifically pointed out that Coca-Cola's detailed submissions distinguishing the prior arts had not been considered.
So Coca-Cola's key argument that their crucial counterarguments were basically ignored was validated by the High Court.
Precisely. The court used this case to strongly reinforce the necessity of this speaking order requirement for the Patent Office. They emphasized that a decision refusing a patent must be a reasoned decision. It has to clearly show application of mind, and critically, it must engage with and address the arguments put forward by the applicant. The failure to analyze Coca-Cola submissions meant the controller's order just wasn't a properly reasoned decision according to law.
It sounds like the court wasn't inventing new rules here, but applying well-established principles. Did they rely on any specific precedent, any key cases?
Yes, very heavily. The High Court's reasoning leans significantly on a landmark judgment from 2020 called Agriboard International LLC v. Deputy Controller of Patents and Designs.
Agriboard. I've heard that mentioned. What did that case establish that was so pivotal here?
The Agriboard judgment provided a really clear framework, essentially a three-part test, for how the controller must analyze inventive step. It's not optional.
Okay, a three-part test. What are the parts?
As cited by the High Court in this Coca-Cola case, the controller is required to consider. First, the invention that's disclosed in the relevant prior art. Second, the invention disclosed in the patent application they're looking at. And third, this is key, they must explain the specific manner in which the subject invention would be obvious to a person skilled in that relevant technical field. How would they get from the existing knowledge to the claimed invention?
Okay, so it's not nearly enough to just say it's obvious.
Yeah.
You have to explicitly look at what's known, look at the new thing, and then spell out exactly how a typical expert in that field would easily connect the dots between the two, step by step.
Exactly. And the High Court, quoting Agribord, reiterated that a bare conclusion, just stating it lacks inventive step without conducting and articulating this step-by-step analysis, is legally not permissible. Unless, perhaps, the obviousness is so blindingly clear that no analysis is needed, which wasn't the finding here.
Right.
The controller must analyze what is the existing knowledge and how the person skilled in the art would move from the existing knowledge to the subject invention. The High Court found that the controller's order in the Coca-Cola case simply failed to meet this standard that was clearly set out by Agribord.
So the core problem wasn't necessarily a fundamental disagreement on the technical merits of inventiveness, but rather the Patent Office's failure to follow the legally mandated process and provide the required detailed reasoning, particularly by ignoring Coca-Cola's specific counterarguments.
That's the absolute core legal deficiency the court identified. And the court didn't stop there. They also drew a connection to broader principles of natural justice.
Natural justice.
Yeah, they cited a Supreme Court case, Manohar v. State of Maharashtra and Ors, which was actually mentioned within the Agribord judgment itself. That case affirms that application of mind and recording of reasoned decision are the basic elements of natural justice. These are required whenever any authority rejects an application that affects someone's rights or interests.
So, fairness dictates that decisions aren't just arbitrary, and that the reasons are clearly stated and demonstrate consideration of the arguments made. Makes sense. So the High Court set aside the refusal order. What did they actually instruct the Patent Office to do next? Did they tell them to grant the patent?
No. Crucially, the High Court did not decide whether the beverage dispenser invention was patentable or not. They didn't substitute their judgment for the controllers on the ultimate question. They didn't grant the patent, nor did they definitively refuse it themselves.
Okay, so what was the order then?
Instead, they ordered that the matter is remanded back to the Patent Office for a fresh consideration.
Remanded meaning sent back for a do-over, basically.
Precisely. With specific instructions. The controller is directed to provide a fresh opportunity of hearing to both Coca-Cola and the respondents.
That fresh hearing.
Yes. And critically, when they issue a new order after this fresh consideration, it must be a speaking order. This new order absolutely has to specifically address the valid submissions raised on behalf of the appellant, meaning they cannot ignore Coca-Cola's arguments distinguishing the prior art this time.
They have to grapple with those points.
They must. And the order must also include that required Agribord analysis explaining the existing knowledge and, if they still conclude there's no inventiveness, demonstrating precisely how the claimed invention would be obvious to a skilled person in light of the prior art. They have to show their work.
So the instruction is crystal clear. Follow the proper procedure this time. Properly consider Coca-Cola's detailed points and provide a thoroughly reasoned decision explaining the analytical path taken, whatever the outcome.
That summarizes the court's direction perfectly. The appeal was essentially concluded with these specific instructions for the Patent Office to conduct a fresh examination according to the established legal standards.
What does this judgment signify more broadly then?
Yeah.
What's its importance beyond just this specific Coca-Cola application?
Oh, this decision is highly significant. It powerfully reinforces the mandatory procedural and analytical standards for the Controller of Patents in India. It strengthens, yet again, the requirement for issuing speaking orders when patent applications are refused.
It drives that point home.
It makes it absolutely clear that cryptic, unreasoned rejections, particularly those that fail to analyze and address the applicant's specific submissions countering the examiner's objections, are legally invalid. You can't just rely on a conclusory statement. You have to show your work and demonstrate you've actually considered the applicant's perspective and arguments. And the decision also firmly reiterates and solidifies that three-part test for assessing inventive step, the one from Agribord, as the non-negotiable standard. The court even pointed out that Agribord has been consistently followed in other high court cases since then, like Rosemount Inc. and Morelli Europe. So this Coca-Cola decision adds yet more weight to that established line of precedent.
It's a consistent message from the courts to the Patent Office about how things need to be done.
It really is. And the fact that the High Court directed its registry to send a copy of this order to the Controller General of Patents for compliance, that underscores that this isn't just about fixing one specific case. It's about ensuring these standards are understood and applied consistently across the entire Patent Office going forward.
So ultimately, this judgment serves as a really crucial safeguard for patent applicants, doesn't it? It helps ensure their applications, and importantly, the arguments they make in response to objections, are taken seriously, and that any refusal is based on a thorough, transparent, and legally compliant analysis, not just a summary conclusion or a feeling.
Exactly. It ensures a level of procedural fairness.
This deep dive truly highlights that while the technical details of an invention are obviously important in patent law, the process by which a decision is reached to the patent office is equally, if not sometimes more, critical from a legal standpoint.
Absolutely. It's a strong reminder that administrative bodies, whether it's the patent office dealing with complex technology or, frankly, another agency making decisions that affect your daily life, have a fundamental legal obligation to do more than just announce a result.
Yeah.
They must clearly articulate how they reached that decision. They need to demonstrate they've applied their mind to the facts and address the specific arguments and evidence presented by the individuals or companies involved.
And when you connect this to your own life, think about it. This principle of requiring detailed, reasoned decisions applies across a surprising range of administrative actions. It could be a license application, a permit approval, a zoning decision, a regulatory finding. Fairness and accountability really demand that the authorities explain their reasoning, especially when they're saying no after you've made your case.
It really does.
It raises an interesting question to leave you with, doesn't it? If highly technical decisions, like assessing whether a novel invention is truly obvious based on intricate prior art and needing to address detailed counterarguments, legally require such a high standard of explicit, step-by-step reasoning and mandated engagement with opposing points, what does that imply about the level of reasoned explanation we should reasonably expect, or perhaps even insist upon, from decisions made by other authorities that impact our lives, even if those decisions seem less technically complicated on the surface?
That's a really good point to ponder. What standard of reasoning should we expect across the board?
Something to definitely think about.